Okay, we now have the pretrial conference. Let me go ahead and go on the record on that. Let's go on the record on DC 209-893 Moss v. Princip. Council, make your appearances.
Good morning, Your Honor. Craig Capua and Royce West on behalf of plaintiffs/judgment creditors.
Gene DuBose representing defendant Holly Bone.
Morning, Your Honor. This is Brian Martin Pro Se for defendant. And thank you very much for allowing me to speak in your court, Your Honor.
Okay. All right, let's go ahead and get started. I instructed the parties to confer on motions and limines, proposed exhibits, as well as any other pretrial matters that needed to occur. And I also understand that there's been a very extensive jury charge that has been submitted. This case has been specially set for quite some time. I told everyone last week that this case was going to have a pretrial this week. I didn't know for sure when, and we set it after I've figured out how long my jury trial this week was going to last. I understand the parties, at least one of the parties, has not complied with my instructions, and so I've never had that happen in 16 years on the bench, and so I'm kind of uncharted territory here. Let's deal first with plaintiff's motion in limine. Have you submitted a motion in limine, Mr. Capua?
Yes, Your Honor, I did.
Mr. DuBose, do you have any objection to plaintiff's motion in limine?
Many. I only got it an hour ago. I also just got a 195-page charge, again, minutes ago. We've had no opportunity to confer on it.
Is that correct?
There are a number of things that I'm clearly going to be able to agree to, but others we will not.
Your Honor, may I respond?
Did you send the court the motion in limine?
I believe we did. If it didn't make it, I can send it again.
I don't have it. Let me see.
Okay. I'll get the paralegal.
Send this to the court. Send that to the court.
It's being resent again, Your Honor. My apologies for the court not receiving it. I had emailed Mr. DuBose yesterday about exchanging all of our pretrial materials at 5 o'clock, so we would have an opportunity to review and confer, but he stated that he would not be ready, and so then we agreed to exchange our pretrial materials today at 8:30 a.m. and both sides did comply there. I mean, I reviewed his exhibits, and
Your Honor,
I don't see the motion in limine.
it's being sent again as we speak, Your Honor.
Rhonda, can you go ahead and forward me the motion in limine if it's come in? I see the charge.
Waiting on it to come in now, Judge.
And Your Honor, as it relates to the charge, that's a draft of the charge. There'll be other iterations, but that is kind of the direction we're going in terms of the case.
It's 192 pages long.
195, I believe. I have only 3 items that I want included in the charge.
Your Honor, if you look at the amended petition, you'll see the various causes of action, and the court will know we've got to make certain that we capture all of those causes against all of the parties in the charge. However, there's an issue, Judge, in pretrial we need to discuss is how to handle Brian Martin, since he has a default judgment. And depending upon how that is handled as relates to the court, that will impact the number of pages in the charge. So, yeah, we're seeking direction, guidance on how we do that in terms of him already being found guilty of most of, if not all of the causes of action that are in this particular lawsuit.
Okay. I mean, I mean, it's just 195 pages is, I've never had a charge over 50. And so I don't quite understand why this would be so complicated, but I haven't read the charge. I've glanced through it briefly, but I have not read it. So I don't know the issues.
And you may not have to read the whole thing. I think how we handle Brian Martin's failure to comply with court orders and the default judgment will affect the length of the charge. And we just need to get direction from the court on how that should be handled.
I mean, I don't want to retry the issue that's already been decided in the default judgment. And so
I'm sorry,
and so but again, I noticed there was like a civil conspiracy. There was all sorts of other claims. But let's deal first with the motion limiting. Did you forward that, Mr. Capua and Rhonda? You sent that to me.
Ms. Benson, did you receive it?
Not yet.
Judge, it's been e-filed and sent to you also.
I don't have it. Rhonda, have you gotten it?
Not yet, Judge. Would you like me to call the office, their office?
But they're on the line right now. They're on the Zoom call. They said they just sent it.
It's been e-filed, Rhonda, and sent to the court.
You sent it through e-file?
7 a.m. to directly to Rhonda.
It went to you, Rhonda, at 10:37.
10:37. Okay, I see it now. Okay, here we go. Just one moment.
Go ahead and forward it to me.
Here it goes.
And Mr. DeBose, have you sent your motion in limine yet?
I don't have any.
You don't have a motion in limine?
No.
Okay. All righty. Well, how long is this? It's only 8 pages. Okay. Let's go ahead and deal with the motion in limine, plaintiff's motion in limine. Which motions in limine do you have an issue with, Mr. DeBose?
With 2, with 3.
All right, so 1 is granted, 2. 2 is granted, 3.
Your Honor,
3
there's
is
one.
granted. Okay, so go ahead and just tell me what you have a problem with.
Well, I do have a problem with 2 and 3.
Okay, those are
with
both those motions and limines are both granted. What's your next one?
Okay. No problem with 4. No problem with 5 or 6 or 7 or 8 or 9. Both parties have, I'm not quite sure what number 10 means as to pretrial orders, because both parties are submitting into evidence the injunctions of the court, and I don't know that
Yeah.
that falls.
What does that mean, Mr. Capua?
As it relates to number 10, Your Honor,
And yeah. Because I've seen that before as any reference to the court motion in limine, but any pretrial orders, you mean at any point in the trial? I mean, any point prior to the day of trial?
Your Honor, I can withdraw it. I mean, that's fine. I think there'll be a lot of orders marked as exhibits, so we're okay with that.
All right, 10 is withdrawn. Any other issues?
Well, 11, because there are damages which were not involved in any discussion. There was no request for those, for the damages.
I mean, is there a request for disclosure in this case?
Yes, Your Honor.
Yes, yes, there
11,
is.
11 is granted.
12, I'm okay. 13, okay. 14, okay. 15, okay. Uh, 16, I'm not sure what all that means.
I'm sorry, I couldn't hear you, Mr. DeBose. Would you say?
I'm trying to read 16.
All right, 11 through 15 are granted.
I'm just not. I'm not quite sure.
16 is denied.
17.
Seventeen is granted.
18. No problem with 18.
18 is granted.
19, no problem.
19 is granted.
We both have videos
Yeah,
that
20 is denied.
And again, I guess no problem with 21.
21 is granted.
Or 22, no problem.
Granted.
So I don't know about that's to Martin.
So 23 is kind of an interesting issue. So there's a default judgment as to Mr. Martin. I agree with you that he can't testify. This is kind of interesting. He can't testify about anything that would be contrary to the default judgment, but he could testify about issues that are not covered by the default judgment.
Yeah. For example, damages.
Damages, yeah, or yeah.
And he will be given a lot of background information. So I'm not.
Therein lies
Sure.
the problem. He'll be given a lot of quote unquote background information.
Yeah.
And so if judge, and I know judicial efficiency, and so we may very well excuse me for the noise, there's construction going on in the building.
That's okay.
We may very well need to take him outside the presence of the jury to see exactly what he's going to testify to see whether or not it's inconsistent with the default judgment. So we won't have to be jumping up and down the entire time. That's just a thought.
I don't think I'm going to be using him for things that are.
I can barely understand you, Mr. DeBose. Could you speak up?
Oh, I'm
some?
sorry. I'm sorry. Can you hear me now?
I can.
Yeah.
Okay. You know, he will be doing a lot of background testimony about what he was doing with and for Ms. Bone, their relationship, things like that. I don't think any of that bears on his liability. It may bear on hers. So I'm just not.
He's never been deposed, right?
That's
He has
exactly.
not. He has not ever been deposed. I'm just not sure I see the necessity of that. But again, if it's limited to liability, I guess, limit and
You keep on going down low, sir, and I'll do respect you can't understand.
Yeah, Mr.
I'm
DeBose,
sorry.
Yeah, I do agree. That's
Your Honor, can I give you an example?
sure.
As it relates to the issue of fraudulent transfer, he's already been found guilty of that.
Right.
Conversion, conspiracy.
I think the main thing I could see him testifying about is the only issue in my mind that really hasn't been resolved in this case, which is why it's so confusing that there's a 195-page charge, is the ownership of the disputed assets. And does Mr. Martin own them or Ms. Bone? I think he could testify about that. Other than that, it's going to be very limited what he could testify about. I don't know background what that means exactly, but background as to that issue, I think is okay. Just general background, that strays too far from that, I would think probably not.
And Judge, while you're thinking about that, there's also the default judgment against Carolyn also. And so depending upon how the judge views how those default judgments should be presented to the jury, it will, in terms of evidence and in terms of instructions in the charge, it will greatly reduce the charge.
Okay. All right. Well, 23 is going to be granted in part, but modified. He cannot testify about anything related to or in contrary to the interlocutory default judgment. He can provide testimony about ownership of the disputed assets.
Your Honor, if I may.
Sure.
Thank you, Your Honor. The main issue I have with this entire case is that these YouTube channels
Mr. Martin, that's not what we're covering today. So,
well, they're celebrity
apologize.
assets.
You could talk about number 23,
Okay.
but that's it. So, if you want to address 23, but we're not going through and re-arguing your whole case.
No, I wasn't arguing it, Your Honor. I was just saying that these channels are celebrity channels. Everybody knows them. They've been viewed over 1 billion times. I provide a lot of information because I've been a part of these channels for such a long time. That's all I was pointing out.
I don't necessarily disagree with them on that. I do think that he can provide some history about these channels.
Thank you, Your Honor.
But, if he starts straying into issues related to the default judgment, Mr. Martin, if you start straying into issues with the default judgment, trying to re-argue those, then I'm going to have to shut your testimony down, which obviously is not what you want. So I'd encourage you to strongly be very, very careful about your testimony. Let's go to 24.
Now, before you go to 24, in terms of ownership, that's already been determined by the default judgment. I mean, follow me just, I'm not trying to argue with the court on it, but if the court granted a default judgment for fraudulent transfer, the fraudulent transfer initiated with Brian Martin. And so for him to say anything otherwise as it relates to the transfer would be inconsistent with finding in the default judgment.
I agree. Related to the transfer, I agree with you there. The issue is who owns the disputed asset, who owned the disputed assets? Was it Ms. Bone? Because there was not a default judgment as to Ms. Bone or Mr. Martin. I can't grant it, and if I did, I'd have to vacate it. I can't grant a default judgment saying that Mr. Martin owned this when Ms. Bone is claiming that she owned it. And so the issue here is going to be discussion of who owned these assets. That's what happened after that point. I agree. If Ms. Bone owned it, then I can't see there being a, trying to think this through. Yeah, I don't know how Ms. Bone, if she had owned these assets, if she could fraudulently transfer them. It's because she owned them. So it was only to the extent that Mr. Martin owned these assets that we would, that there would be a fraudulent transfer claim. So I just think this comes down to the issue of ownership. Let's go to number 24. That is,
I have strongly opposed that because Ms. Bone's autism affects her entire personality. Not to be able to bring that up, and a lot of the way she thinks, the way she acts is unusual. To not allow her to testify about that or about how it affects her would be like in a lawsuit where somebody was, the question would be whether they heard a comment or not, and bringing up the fact that they're deaf would bar that because she is
24 and 25 are denied, but we're going to keep it limited. All right, that's the motion. Plaintiff's motion in limine. I've ruled on all of those now. Defendant's motion in limine. There is not one. Do we have an exhibit list for the plaintiffs?
Yes, Your Honor.
Okay. Did you provide that to the court?
Yes, Your Honor, when we did with that previous email.
Oh, it's in the email. I didn't see that. Let me go check it.
Sure. Let us make certain, Your Honor.
I don't see it with that email.
Okay. Mr. Cappy is checking on it right now.
Your Honor, with respect to their exhibit list, there's some things on it I know, I've seen. There are a number of things that are just named there. I just sent them an email asking them to provide me with about 20 of those exhibits because I don't know what they are. I don't know whether they've been previously produced or not.
Mr. Cappy, you're going to say something?
Yes, Your Honor, I apologize. I thought Mr. DuBose was finished. I can tell the court that any exhibit on our exhibit list has been submitted to Mr. DuBose through discovery. We're not asking for any exhibits to be.
But excuse me, I still don't know what they are. They may have been. I've received massive numbers of documents. A lot of those may be objectionable because they're hearsay or unauthenticated. And those are objections that I think cannot be ruled on at this point. when I hadn't seen the
How many exhibits are we talking about?
the ones that I haven't seen,
No, I'm just, how many total exhibits are we talking about?
54 exhibits. Some of them are very large.
What I would suggest we do at this point, two things, and I'm maybe a little bit optimistic about this. The first one is for the exhibits. Let's reconvene at 2:00 so Mr. DuBose has an opportunity to confer with Mr. Capua about the exhibits. And then for the charge, 195 pages, Senator, Mr. West, if you guys could provide me maybe just an edited charge that says, this is what we need no matter what you do, assuming that you do what we think you're going to do with the default judgment, these are the things that we would need if say, for example, I vacated the default judgment or the default judgment didn't exist. These are the additional questions we would need. So I have some idea of what you're talking about, but I don't have any intention to vacate the default judgment. I don't have any intention, any of the default judgments. I don't have any intent. I have intention that those are in full force and effect as to Mr. Martin. The question is just as to Ms. Bone. I don't believe it should harm her defense on issues that are solely related to her. And so, does that make sense?
It makes sense. There's also a default judgment as it relates to Brian Martin's mother also. So
okay, all the default judgments, whatever there are.
Best case scenario.
And I would ask if you can, I have only 3 issues that I want to be in the charge. One is you've accused her of a fraud, so it's a fraud issue. The second is it's actually a copyright issue. That is the ownership issue. I don't know if you have that in your thing. And the third one is the provision of the family law, which is that the earnings she gets are what called personal earnings, and that's defined it's been defined by the Supreme Court. Those 3 issues I need to have in the charge. And I think the first thing that happens has to be, I've phrased it as a copyright issue because that's the only way that this can be owned. That's what you're owning, is the copyright. And that should be absolutely the first issue, because if that's decided in favor of Ms. Bone, the whole rest of the case against her goes away. So I think and Judge, you're absolutely correct. That's the central issue. The rest of this stuff may follow, maybe not. I have massive numbers of issues. But if the jury decides that she owns these videos, she created these videos, then the whole case is over.
Well,
So that needs to be there. It needs to be absolutely right at the front. After all the usual.
I agree in part with you, Mr. DuBose. I do think the ownership of the channels is not a copyright issue. The ownership of the videos is a copyright issue.
Yeah, and the thing about the channels is that
the last part of it.
I'm sorry, Mr. West.
Judge, you were saying something. I didn't hear the last part of what the court was saying.
I said that there's the ownership of the channels is not a copyright issue, I don't believe.
No, but the thing is that according to Google's own terms and conditions, nobody owns the channels. It's a license. They allow people to do these things, and they can take it away whimsically. They have done that in this particular case. They've just taken it away and closed it down. And their terms and conditions say that there are no contractual relationships. It's just a convenience that they allow to people. So the real issue here, because the channels are unownable, is the videos themselves. And there's a kind of a presumption that if you are filing a video on your channel, that you created it, because their terms and conditions at the end, again, are very specific. You should only post on your channel that to which you have copyrights. Or
so Mr. DuBose, I get that. So, and remind me again, for each particular video, when someone gets paid or an entity gets paid from Google for advertising revenue or whatever, is it paid by video or by channel?
by video. As a matter of fact, they have a very careful auditing on this stuff. And if you are the person who has the access to the channel, you want to call them owner, whatever, then every time money is paid, you can go to each video and see how much of the income comes from that particular video. It's very, very specific stuff. So all the channels is the avenue through which the income that's due to the videos comes to the person, and then it goes into whatever account. And in this case, all the money that we've seen went into Ms. Bones' account.
Your Honor, may I respond briefly?
Sure.
This case is not complicated. Here's the issue, Your Honor. If you and I are married and I upload these videos, I say that Judge Hoffman is the owner of these videos because there's a judgment against me. So I don't want to say I'm the owner. No one's going to check unless someone files a complaint. Well, since you and I are married, well, of course, you're not going to file the complaint. I'm not going to file the complaint. It's only going to be a third party who's going to file the complaint. That's the whole basis of this lawsuit in a nutshell. So just because you upload a video doesn't automatically mean you're the owner of the video. Google and YouTube presume it is because that's their terms of service. But what does that mean? It doesn't mean anything. It's not like you're signing under oath, you're the owner of the video. And that's what the evidence is going to show.
Sounds good. Let's shorten up this charge. You guys confer on the exhibits. We're going to reconvene at 2 o'clock. And Mr. DuBose, have you provided an exhibit list to Mr. Capua?
I have, and I've provided all the exhibits as well.
Okay, so you guys need to confer on this. We'd try to pre-admit as many exhibits as possible. And we'll discuss that at 2 o'clock. Also, if you guys could discuss the charge between now and 2 o'clock, that would be great as well. And hopefully we can get this shortened up. We'll see you guys back at 2 o'clock.